So I trust everyone can see the questions that are being posted. Hi, Barb. How are you doing? It's really, well, one of the things that we enjoy the most is seeing people again, you know. You can see the slides that we're sharing and smiling faces. And we make a very strong practice that we don't do things that are litigious, argumentative. We help people to moderate problems, we help people solve problems. But there are two types of lawyers. You may know there's essentially a split bar. There's barristers and solicitors. And barristers stand in front of the bar or behind the bar and in court, and they litigate. And of course, if you pay them, they'll litigate, right? And solicitors deal more with peace of mind, financial matters, wills and trusts. And the real divide here is that there's two types of lawyers. There's the ones that walk you to the courthouse and the ones that walk you to the bank. And we prefer to walk to the bank because it's shorter. These are the statistics that show that 1 family in 10 in Ontario, and it'll be the same pretty much everywhere else. We're starting to work with families in Barbados now, and it's the same kind of statistics. It's 1 family in 10 that is a parent household of a child with special needs. And you can see here by looking at the numbers, you can look in more detail. I'll try to be brief. You can see the number of the population of Ontario. And what StatsCan says is that if you divide that by 3, you get the rough number of households, which sort of intuitively makes some sense, right? And if you then look at the number of people that are on ODSP, and you calculate what 10% of the households would be, and then you give some thought to all of the people that aren't on ODSP that are under 18 and over 65, which is about 1/3. What you wind up with is a number that is very close, very conservatively correct to 1 family in 10, which is an amazing thing. This is the ODSP statistician's breakdown of the types of disabilities that people have. It's not very specific. It doesn't have for example, categories for Down syndrome. We just did an event with the Down syndrome Durham, for example. And it doesn't have anything about autism. But these are the rough breakdowns of the types of disabilities. You can see by cognitive or physical or mental health balance issues. And these happen to be the numbers in your particular municipality. And you can take the population of your municipality, look at the numbers that are on ODSP, gross them up by about a third approximately for people that aren't 18 to 65. And you'll see that in your community, in most communities, it's 1 in 10, although it's higher in certain places like Sudbury, where it's 1 in 5, because it's a service center. So now we're getting to the more quantitative information here. We deal a lot with benefit increases. 14% of people on ODSP are at home with family, which is about 48,000 people. And they are always slotted into the room and board amount of $896. Anyone here who has their child or their family member with them at home knows this, that they are slotted into $896. And we have a technique to get it increased in a lot of cases to $1169. Karen, I'm going to ask you in a moment to say a few words about this. But what happens is if a child can chop and cook, which many can, even if it's with support and guidance, we can often get this increased to $1169. And I did a quick calculation the other day, and with just the families that we have assisted so far, the result of our efforts is that those families receive approximately $1,644,000 more each year than their equal families that we have not assisted. So we're kind of proud of that. Our fees are typically contingent fees. And Karen, what do you think about half of the people that we assist pay using the money that we get for them? What would you say?
A little more than half. I offer payment plans. Some parents opt to pay it and then get it back from the children, but it takes about 10 months to recuperate all your money back.
Yeah. So I think that's a pretty good return on effort. The other big thing we do, one of the things that is not wills and trusts, for example, which is the core motivation for why people contact us. What will happen to my child when I'm gone? This is the core motivation. What we do is we try to put money into the client's pocket before they engage us and pay us to do other things. So we do a lot of work with retroactive recaptures, approvals and recaptures for the disability tax credit and the caregiver tax credit. Caregiver tax credit is the parent's credit. It's only applicable if the child is over 18. And up until 2017, the child had to live with you, but then they removed the reside with criteria. And this can be applied to everyone. And the wonderful thing about this is you see this number here. Well, if you look, you'll see that what they call boarders those are the kids at home on ODSP that are getting room and board. It's about 14% of the total number. So until 2017, only the parents of those kids could use the caregiver credit, which reduces your taxes by about $1,000 a year. But in 2017, they removed the reside with criteria. And so now the total number can use this. And I think that's a great big improvement, because now you're talking 378,802 times $1,000 a year when it starts to add up. So those are two of the interesting things that we do. Karen, do you want to say anything about how long it takes for these tax credit recoveries? The fees on this are contingent as well, based on success. Do you want to speak to that just for a moment, just how long it takes for this process?
It could take anywhere from 2 months to 6 months. It depends on how fast your doctor, works with us, and quite frankly, how fast CRA wants to work. And when I say wants to work, it's just the adjustment part of it. We take care of them about 3-year chunks, but I have clients that, it takes a little bit to get them completed. So I usually say 2 to 3 months. A little bit faster if you've already been approved for the disability tax credit. But yeah, it's not too bad.
It's very gratifying work, because all that's happening is we're getting people money that they should not have paid in taxes.
Absolutely.
That's all it is. Victoria, are there any particular questions that deal with benefit increases or tax credits?
Yeah, we have a few. So Brian had asked, do you need to have a valid disability tax credit or T2201 when the will is executed? Ken, if you want to speak on that, or I can.
No, it's completely separate. It's just tax credits. It has nothing to do with the will.
And then there was a question from Nellie. They asked, if the person with the disability transferred the credit to a family member, how does the family member get the refund?
Well, we have to adjust the credit on their tax returns for the last, it's commonly a 10-year recapture. And so we readjust line 31800 transferred. You have to affect the transfer of the credit. There has to be grounds to transfer the credit from the person to the tax-paying family member. They have to help to some extent with food, shelter, or clothing, the necessities of life. But otherwise, it's just a process of getting the credit approved or getting it transferred. And then once that's done, oh, by the way, we do the adjustments. This is criteria for people to receive ODSP. The forms have just changed in August. It's an online process. You can start to prepare for it if your child is approaching 18. You can prepare for it 6 or 8 months in advance. If you happen to have a child with some cognitive impairments, developmental disabilities, then you would start to be involved with Developmental Services Ontario. And then if they take the child on, say, yes, this child has a developmental disability, then they'll provide a letter to this effect, and they'll provide other supports as well. But the letter is sufficient to establish medical disability for ODSP purposes. So then you don't have to have the doctor fill out the form and send it to the disability adjudication unit and so on. Makes the process smoother. You can see again here that the benefits are room and board or shelter plus supplementary, plus drug and dental, plus lots of other supplementary things. And of course, there are related supports like assistive devices programs and so on. The simple rule is that the person on ODSP can receive from any source up to $10,000 over a 12-month period, but that is by no means the limit of what they could receive. We have techniques to get unlimited amounts of money, either, if appropriate, into the hands of the person on ODSP, which is not typically the case, or spent for their purposes. You can see now that the asset test is $40,000. It used to be $5,000, and this $10,000 over 12 months used to be $6,000. So if you aren't aware of these increases, it does provide a lot more flexibility. This is a slide about the process to get approved for the credit. Are there any other questions, Victoria, about disability tax credits and being approved?
There was one question from Stu. He asked, how can I find out if I'm recovering all of the disability tax credit?
Well, if the child is over 18, it's about $1,600 a year. And if the child is under 18, it's about $2,200 for each year. I'll just give you a second to look at that slide. The other main tax credit recapture is the caregiver credit. It's used by caregivers. The test, there's no pre-approval for this. You just have to be a caregiver. And then you have to file a Schedule 5 and do the adjustments. And you need to have a letter or an assessment of some sort to backstop the nature of the disability. But you can see here that this slide is slightly dated. A 10-year recapture, which is probably our most common, is about almost $10,000 now. It's about $9,600. And since 2017, as I mentioned, it's $1,000 a year. So we're in the process now of assisting families that, obviously, prior to 2017, they either didn't know or had been told that they couldn't use it because the child was in supported living. Well, now they can. And they changed the lines on everybody there several times. So the lines that you might have known before, they're different now. Are there any questions about caregiver credits, Victoria?
A lot of the questions were just talking about eligibility for the caregiver credit.
I see, okay. I'd like to, well, no, we'll wait till RDSPs. We'll be there soon. There's a question here from Jan about RDSPs and what happens when the parent, as the account holder, passes on. So we'll come to that. Or Karen would like to answer it, so Karen will answer that for you, Jan. One of the big things about the disability tax credit approval, aside from the fact that it reduces taxes, which is nice, is that the child can then have an RDSP, a registered disability savings plan. And as you can see here, if you do nothing, if you open it up, let's say the child's 18, based upon child's income, which is ODSP, if you do nothing, the government puts $1,000 a year bond for 20 years into the plan. And if you contribute $1,500, the government puts a further $3,500 in grants for 20 years. Now, we'll come to the calculations of how this will grow when it's invested in just a moment. Do we have any preliminary questions about RDSPs, Victoria?
Yeah, so Ruth asked, when can an RDSP be withdrawn?
Well, the formula is slightly complicated, so I will say a few words about that. So we've got lots of questions here. I guess everybody's trying to answer things.
Ken, the one from Miss Jen, I put answer live just so that he knew they were going to answer it live, because I thought you said you were going to answer it.
Is this me?
Yeah, Jen, I am the plan holder on my daughter's RDSP.
I can answer that if you'd like, sure.
Please.
Sure. So Jan, what happens is the parent can be the account holder for a not competent child. They can obviously be the account holder for a child who's not competent because they're a minor. When they turn 18, they are ostensibly competent, but of course, in 30 to 50% of the cases, they are not actually competent, right? But if the child is not competent, then the parent can continue to be the account holder, but no one else. Well, that's not strictly true. The spouse of the person with the disabilities could be the account holder too, but that's a rare occurrence in a lot of cases. So what happens is there is no subsequent provision for someone to be the account holder for the not competent person when the parents are gone. And what this means is that you then have to have legal guardianship to be the personal representative of the person who's not competent in order to be the account holder. So we do a lot of legal guardianship applications. They're all uncontested. Nobody's complaining. Nobody's contesting. They're all for the benefit of the child, so that someone can be the account holder. And I'll get to that actually. Let me just go to this next slide, and then I'll talk about. So it's the context of why it's so critical that there be a discussion about legal guardianship. And when we get to those slides, Diane will speak to the differences between powers of attorney and legal guardianship. So you can see here the matching monies. And I'll show you the calculation in a moment, but you see this line here. If you open up one of these RDSPs at age 18 for the child, and you make all your regular contributions, $1,500 a year, and of course the tax credit saves you $1,600 in taxes. So it's essentially self-funding. The taxes are reduced by $1,600, and then you put $1,500 into the RDSP. So you do this for 20 years, starting when the kid's 18, let's say. And you put in your 30,000, the government puts in 90, and you invest it at 5%, which is reasonable, even in today's world. Maybe it'll be more, given inflation. We'll soon see, right? But if you started this at age 18 and left it invested, made the contributions, it would be approximately $700,000 by the time the child's 60. And with respect to withdrawals, you can take money out anytime you want. That's not an issue. The only problem is that it's last in, first out. So if you contribute $1,500 in the 18th year of the child, you have to wait for 10 years before that first $1,500 and the 4,500 grants and bonds are vested. So thereafter, if you should try to draw out $1,500, you're not drawing the $1,500 you put in at age 18. You're contributing $1,500 that year, and then you're drawing it out again, and you're losing the grants and bonds with respect to that year, working backwards. So if you start at age 18, you contribute for 28 years, child's 38. You then have to wait at least until they're 48 to be able to withdraw without losing grants and bonds. And the way the plans are set up, the intention is that you wait till they're 60, but obviously many families are planning in between. There's a possibility, there's a sort of a move afoot to see whether the money could be used perhaps the same way a self-directed RRSP is to provide a mortgage, self-provided mortgage to buy a home, that sort of thing. But there's no way at all to predict whether that will ever come to fruition. So basically, you have to wait 10 years from the last contribution. And we do have clients who want to discuss, well, should I stop at a certain point? For example, if you have a daughter with Rett syndrome, it's an unfortunate fact, but the child may well not live past 50. So you say to yourself, well, I want to contribute, I want to get the grants and bonds, but at some point before my child passes on, before me, I want to start using this money for my child's benefit. So when should I stop so that everything's vested? Well, you shouldn't stop. You should continue to contribute $1,500 a year for the whole 20-year period, because the worst that happens, as compared to stopping at a certain point, is that you have continued to contribute, you've continued to get the grants and bonds, and when the day comes that it's appropriate to start to withdraw and the total grants and bonds are not vested, okay, so all that happens is you get money out and you lose the grants and bonds that you would never have had if you had stopped contributing. So tactically, I can't see any real sense in trying to pick a year to stop. Just keep contributing, and yes, it's true that when you make that decision to start to withdraw, you're going to lose the non-vested grants and bonds. Well, so what? All right. This is just the calculation. You can see here how the calculator works to get you up to $700,000. Victoria, do we have other questions about RDSPs or contributions?
Sneha had asked, how do I invest RDSP money to grow well?
Well, you need a financial advisor. I wouldn't recommend that you deal with a bank unless you have an advisor at a bank. And of course, if you set up the RDSP with the back office RDSP people, they don't provide investment advice. They just help you set up the plan. So, if you happen to be able to then be self-guided, which, many people are, you could put mutual funds or GICs, for example, into the RDSP. But since you're looking at trying to get a 5% return, and you're looking at a long-term arrangement here, just say to yourself, when my son turns 18, my other son turns 18, I'm going to set up a TFSA for him so that he can learn financial literacy. And I'm going to put $6,000 a year into this TFSA, which is exactly the same thing that is happening with the RDSP. You're putting $1,500 in, and the government's putting $4,500. That's $6,000, just like the $6,000 annual contribution that a person age 18 and older could put into a TFSA and then invest it. Well, are you going to put $6,000 of your money into a TFSA for your son and not get advice on how to invest it? You're not going to do that. So, because of course inflation, the mandate of the Bank of Canada is to maintain inflation at 2%. And the reason for this is that the government of Canada issues bonds and people buy them. And what the government pays back every year, is the capital portion is deleted or depreciated by 2% each year. So if you hold this bond for 50 years, your capital has deteriorated by 100%. But yes, it's true, you've earned whatever, pittance of interest it has earned. And it's the difference that's the loss. Yeah, I got that part. But the purpose, the mandate of the Bank of Canada is to ensure that inflation is 2%. I've been through a lot of inflation up and down, I remember the terrible things that the Bank of Canada did to Canada back in '73 and in the early '80s. It just decimated businesses and families and bankruptcies and divorces and business collapses. So all of the stability that the Bank of Canada tries to generate with its 2% mandate has destroyed families for decades. That's my little rant for the day. I hope you enjoyed it. But I happen to know that it's true. This is just some more information about the calculations of RDSPs. Other considerations, you don't really need to think about this. Are there any more RDSP or DTC or those sorts of questions before we carry on?
Ken, people are asking what line to check for the caregiver amount.
Lovely, thank you. So there are 3 caregiver lines, and they vary slightly. For example, one is a dependent under 18, one is a dependent over 18, one is a dependent with a disability. So the ones that we're looking at is line 30450. It could be, that you're using 30400 or 30425, but the best line is 30450. And if you find you're not using it and your child's over 18, let's say 28, let's say, and you're one of that 14% where your child's at home with you, well, give us a ring because we can help you recapture about this side of 10 grand. We're doing pretty well. That's 7:30. I think we're doing well. What are we doing with the questions and answers? I haven't really been able to follow that. I've been talking. I see lots of questions.
We have 62 questions that we're trying to answer still, and we've answered 58 so far.
Oh, wow, that's great. I think, what was your record the last time? 175 in an hour and a quarter, I think?
187.
Yeah, and that was just you or the group?
It was me and Diane. Diane and I.
I can see you're all typing away there. You're intently looking at your keyboards. That's great. Diane, I'm going to ask you to speak in a second here. I'll just say a couple of words, and then if you wouldn't mind, if you could speak to the guardianship process and the powers of attorney and so on, okay? So what happens is when a child turns 18, if they're competent, or even if they're modestly competent, we'd like to help with powers of attorney for property and personal care. There's a very modest fee involved. And what it does is it allows you to then continue to assist your child as you probably were able to when they were minors. But of course, you have to have a power of attorney for property and personal care for an adult. And of course, everybody should have them. So if the child is competent, we'd be happy to help you put that in place, because it's inevitable that the day will come when someone won't give you some information, or they'll make a decision that you haven't had the ability to take part in about your child because they think they know best. Well, they don't know best. You know best. My clients, my families, they're the experts here. All of the other supporting professionals, they're just supporting professionals, right? That's how it goes. And that includes me. And the way I like to describe this, those of you who have been through one of these seminars before, you probably heard this. But if you look at the supporting professionals, as well-intentioned as they are, and the family, and if you put it in the context of an egg and bacon breakfast, the chicken's involved, but the pig's committed. And that's the fact. Clients have skin in the game. And whatever happens, they're the ones that are going to be there day and night till the day they die. So the lack of humility that you sometimes see in supporting professionals who think they know best. They know lots of things. I know lots of stuff. But do I actually know what's best for your child? No, I don't. You do. I'll just help you do what you think is best. But there are a lot of cases, 30 to 50%, I would say, of our client families where the child is not competent. So in that case, you need to have legal guardianship. And the way I describe it is you don't necessarily have to do it right now. It's not, a lot of times, you're not having medical issue problems. You are the ODSP trustee, that's fine. You can be the account holder on the RDSP, that's okay. You get cooperation from other people. But the day comes when you, the parent, are at that awkward age where, say you're 60 or 65 perhaps, and you're not going to die anytime soon. That's unlikely. You got 20, 30 years to go. But what happens is you understand mortality. And of course, your primary concern all of these decades is what will happen to my child when I'm gone. I just want to live one day longer than my son, right? I've got some cases where that did happen, but it's not common. So what happens is when you're gone, who is going to be the successor to make sure that your child is cared for, and that when they're in a supported living environment, because they were living with you, but now you're gone, now they're in a supported living situation with the huge industrial supported living organizations that exist, which are an industry. Who is going to watch over your child? Who is going to be the administrator, the account holder for their RDSP? And when we get to it, if you're a teacher or an OMERS employee pensioner or a power generator, there's a potential for 50% of your original pension to pass on to your adult dependent child. Well, somebody has to apply for that pension and receive it. Who's going to receive this $30,000 a year that gets paid out of $700,000 RDSP when the child is 60? So you can see that when the parents are gone, there's an issue here. And if you're fortunate enough to have siblings for that child, not everyone is, then how will they handle this? And do you want to leave that problem to them? So, you know, there is an expense involved and time involved. Diane, would you mind talking about the mechanics a little bit about how a legal guardianship application works?
Sure, be happy to. So the way that we do legal guardianship here is through a process called summary disposition. And what that means, it's a basket application in writing. The application itself is going to be about 120 to 200 pages long, and what it consists of is affidavits from the applicants, and then what's called a management plan and a guardianship plan. So the management plan goes through the assets of the allegedly incapable person, and then we go through what the applicants plan for those assets after guardianship is received. And the second plan, the guardianship plan, that goes through the medical needs and medical history and just the daily life experiences of the allegedly incapable person. And then again, what do the applicants plan to do after guardianship is received? And we also have to include evidence as to the incapacity. And the way that we do that is through submitting what's called capacity assessment reports. And so we get a capacity assessor, two of them, to meet with the allegedly incapable person, and they'll ask questions about, you know, their finances and their just ability to comprehend managing their daily life and their expenses. And if we get a report that says that they do find them incapable, we'll include that in the application. We would also include consents from immediate family members. And then this application is bound up and it's sent to the court. And one copy is given to what's called the Office of the Public Guardian and Trustee. And what they do is they review the application. And if they have any questions, they write to us. And if we answer them, we write them back. And if the judge has any questions, we write them back as well. And this is something that we can file in Ottawa. So, you know, our clients can be in Toronto, they can be all over Ontario, but we can file them in Ottawa, where we are located.
That's great. Thank you very much. How long does the process usually take, do you think?
I would say it would take about 6 months minimum.
That's what I'd say, yeah. Depends, of course, on, you know, whether the judges are sitting and so on, but that's, I would say that's about right. Let's see, we have 451 attending. That's a new record for an evening event like this. This is just a slide about powers of attorney for personal care. And of course, we, you know, these are things that are part of the package of documentation that is provided for the parents as well, of course. Powers of attorney, will, trust arrangements. We will get into a little bit about the trust arrangements. Jennifer will speak to the essential elements of a Henson trust when we get to that slide. This is something that is available. We frequently find that parents say, oh, I am my child's guardian. Well, no, you're just his parent. But what a parent can be and is, if the child is not competent, is their statutory substitute decision maker, but just for personal care. And the problem with it, compared to guardianship, is that it just doesn't have quite the same clout. See, with a legal guardianship in a medical care situation, someone has to grant informed consent for any kind of treatment. A substitute decision maker could do this, but it's just not, although it's well known by the medical authorities, doctors and hospitals, they know all about substitute decision makers. That's not the point. They just don't get the same clout. They're seen more as somebody that you might want to sort of, talk to if you feel like it, or, because what happens is in a medical scenario, doctors and engineers and lawyers and so on, they're all taught to unpack problems in a given way. A doctor does it in a triage method. And what happened was some years and years ago, perhaps during the American Civil War or Boer War, maybe Gallipoli, Frances Nightingale, what happened was they finally realized that you couldn't put all of your medical resources into people that were going to die. You should direct them towards those that would likely live. And then you'd compartmentalize people into triage, right? Into three compartments, ones that are likely to live, ones that might live, and ones that won't live. So you don't put your main focus and resources on the people that are just not going to make it. Now that's a rational thing to do. The problem is that in the context of people with disabilities and old people, there's a triage bias against them. And it's kind of like, if you're a broken bicycle, why fix the tires? And I've seen examples of this. I know it's a fact, both with elderly people and with people with disabilities. So what happens is the medical system, which is for the most part well-intentioned, I think we all have our own opinions about wait times and surgeries and stuff, of course, which haven't been helped by COVID, of course, too. But the point is that people with disabilities and old people, there's a certain bias against them. And you have to, as always, be their perpetual, eternal advocate for medical care. Everybody here knows that. And, maybe many people are sufficiently lucky that they don't have this as an ongoing daily issue, but that's a fact. So if you are the substitute decision maker, you'll get a certain amount of attention and cooperation, but you'll still be treated as somebody who doesn't really know what's best. You're not a doctor. And as far as I'm concerned, that's not it. That's just not how it's supposed to work. So a legal guardian clearly stands in the shoes of the person with disabilities, the not competent person. They work hard to give as much agency as possible to their child, to their brother. They try to do what's best for them. They know them best. And legal guardianship, of course, deals with both medical care, informed consent, and also property in all those matters. So it's almost 7:45. This brings us to a very important, a very important point. People that are teachers or municipal employees or power generators, hydro, Bruce Nuclear, or workman's compensation, WSIB, people who will have those pensions, these are provincial statutory pensions. And as far as I know, it's the same across all the provinces because they're all unionized and they're all standardized. Provincial statutory pensions. So if you're a teacher and you have a $60,000 pension, and perhaps your wife is a teacher, she's got a $60,000 pension. Well, this is great, right? These are good pensions. So you retire at a young age, have a long and healthy retirement, but you have a child who has Down syndrome or autism or some other disability. Well, if they were adult dependents, survivors of yourself, adult dependent survivors, then they would stand potentially, and in many cases, to receive 50% of your pension, your original pension. Because of course, if it's just you and then your spouse, you have your pension, you pass on. It's always the guy that dies first, right? So the guy dies, his wife gets 66% of his pension, and then the mother dies, and the child potentially can get 50% of that original full pension. And so it would be, let's say, $30,000. Well, you have to be competent to apply for it and competent to manage it on behalf of that person. So they need a legal representative, which could be a power of attorney if they're competent, but otherwise you need legal guardianship. So now we got the pension plus RDSP. And this is a very big thing because, of course, the $30,000 is greater than $14,400 for ODSP. So, of course, the person loses ODSP. A common question, very common, is could I have that pension directed to the Henson Trust? Well, no, because it's a pension. It has to be paid to the person. But you can see how big this is in the sense of estate planning. If you have a $700,000 RDSP for your child at age 60, and the child's 60 when you pass on at 85 or 88 or 90, right? So all of a sudden they've got a $30,000 pension. You've invested the money. It's accumulated to $700,000 in the RDSP. Starts to pay out $30,000 a year for 24 years. Your child has a $60,000 annual income. Who's going to manage this money? And if they're in supported living, they can't use it. So what happens is it's accumulated by the legal guardian on behalf of the person. Whatever is needed for them is used for them, but the rest of it is accumulated and invested. And then when they pass on, they are not competent to have done a will, so they die intestate. And if they have siblings, brothers and sisters, then by succession law, the brothers and sisters inherit this money. This kind of thing has never happened before. Do we happen to, Victoria, happen to have any questions about pensions? Did anybody ask about that? It's less likely because most people don't know about it.
No, I don't believe so.
Okay. So that brings us to Henson Trusts. I think we're right on track here. And Henson Trusts are just testamentary trusts. They're trusts in a will. You could have what's called an inter vivos trust, a trust set up while alive, but that's not common because most people don't have the money to fund the trust until they're dead, and then they do. And there's lots of people that are going to die millionaires. They just aren't millionaires right now. Jennifer, would you like to speak to these essential elements of Henson Trust?
Yes, I would love to. Good evening, everyone. I'm so glad you came in to join us tonight to ask us all these questions, and some of them are quite good. Now, one of our main components for our estate planning is the Henson Trust. And what, in a nutshell, is the Henson Trust? Well, it's a testamentary trust. It's written into your will that protects your child's inheritance, most commonly from ODSP clawback. So, but not all trusts are Henson Trusts. Henson Trusts actually contains specific language that ensures that everything is copacetic, that it's a Henson Trust. So for example, wording must include what we call an absolute and unfettered discretion. This is the discretion of the trustee to pay the beneficiary a set sum either per month or per year. Now, when we also talk about shall not vest, income and the capital shall not vest in the beneficiary. It means that for math's sake, we have a $500,000 Henson Trust that was set up by a parent for the disabled child. At 5% growth, it's roughly, and forgive me if my math is a little off, it's $25,000 income per year. Now the capital is $500,000. The income is $25,000, but if the beneficiary's needs are modest, they're in a group home or whatever, then they may only need a $10,000 payment per year. So the remaining $15,000 of the income is just simply reinvested into the Henson Trust. Like I said, just make sure I got this right, is ensuring that the payments to the beneficiary are at the discretion of the trustee, and the capital of $500,000 and the income of $25,000 does not vest. They only receive the payments that the trustee will distribute. Now, when we talk about the even-handed principle, The even-handed principles we talk about, we don't favor one set of beneficiaries over another. Now, in a Henson trust, there are two types of beneficiaries. There's the capital beneficiary. Those are the people or organization that may inherit the residue of the Henson trust when the beneficiary passes away. And then we have the income beneficiary, who also could potentially be the capital beneficiary. And that is the beneficiary of the Henson trust, who receives income from the trust either monthly or yearly. Now, the even-handed principle is like you don't favor one class of beneficiary over another, but the Henson trust refutes that principle, meaning they don't follow it. So we don't follow the even-handed principle. It simply means that any decisions regarding investment, disbursement will always favor the beneficiary to ensure the comfort and maintenance that the beneficiary may be used to. Now, the size of the trust, we get a lot of questions from prospective clients who, well, I have like $500,000 or I have $200,000. Is there a limit to a Henson trust? No, there isn't. However, the ODSP office, they have what is called an inheritance trust, and that is a $100,000 limit. Henson trusts do not have a limit. You can put $1 million, $500,000, whatever. Now, the disbursements, according to ODSP rules, beneficiaries may receive up to $10,000 as income from the Henson trust. However, the disbursements, in addition to that $10,000, could be unlimited. A suggestion would be that the beneficiary, the trustees, accountant, bank manager, the beneficiaries informal support team, they would come together at least once a year and to come up with a budget, rent or internet or groceries, food money, spending money, that sort of thing. And what would be done is that the Henson Trust trustee can make a lump sum payments to third-party vendors, like for example, to the person's rental person, or to the cable bill, the telephone bill. And that just works around the 10,000 disbursement out of a Henson trust, so that the person is taken care of for a year. The rent is paid for, their cable is paid for, that sort of thing. But at the same time, they'll actually have 10,000 in their bank account, which would be, spending money or, food money, that sort of thing.
Oh, that's good. Well done. You want to talk about lifetime benefit trust for a second?
Yeah, I'd be more than happy to talk about lifetime benefits trust. In addition to a Henson trust, we are getting a lot of questions. Hi, Richard. We're getting to your question about registered retirement savings plans. We're talking about RRSPs and RRIFs, like RIFs, life income funds. Some of our prospective client families will have large RIFs, large retirement plans, and it's like, I'm not going to get through this money in my lifetime, but I want to ensure that my disabled child is protected. And one of the things that we would do is a lifetime benefits plan, or a lifetime benefits trust. Now, in the normal course of events, when a person dies, their RIF, the registered plans, will be subject to tax, and it's roughly about 50%. So on a $500,000 RIF, you're losing at least $250 to tax, when we can actually have that $250, benefit the beneficiaries. So let's see, example one, which is like the $500,000 RIF at death. So when the testator or testatrix passes away, the parent passes away, they have a child who has a cognitive disability and is dependent upon the parent. So what happens is that the RIF is rolled over into a lifetime benefits trust. And currently, an election has to be made to transfer the RIF amount tax-free over to the lifetime beneficiary. So looking at this example that we're showing you here, so a $500,000 RIF will leave you $250,000 for your child. However, With a lifetime benefits trust, it's an annuity is purchased, a qualifying annuity is purchased for the child. And the child will start receiving that annuity. For example, if the child receives the annuity at age 58, as we have the example here. So the annuity is will last definitely 20 years, with an income being paid out of roughly $24,864 per year for the next 20 years for the child. So by that time, the child would be, Jen does not do her math very well, so 78. But if that annuity is still being paid, that annuity will also be paid out past the child if, as, the interest accumulates and that sort of thing. So the income is attributed to the disabled child as opposed to the deceased parent. So we have an annuity that's roughly 24,000. That income is attributed. So we have the basic amount, which is roughly about 14,000. And then we also have the disability tax credit, which is roughly about 8,000. And this is what the beneficiary would, we would subject to their income tax return. It's the personal credits that everyone can claim. So what happens after everything is applied, all the basic credits are applied, the child has a taxable income of roughly about $3,200. Now, $3,200, we pay income tax at roughly 22% per year for the next 20 years, which is roughly $708 per year for the next 20 years, which comes out to be roughly $14,163. So what we do in order to, we do a sample annuity for any prospective client, and we get your date of birth of yourself and your child, and then we do an annuity plan. Now, the tax savings that comes in is we take that $250,000, we minus $14,163.60, which gives a tax savings of $235,000. So that's an extra $235,000 that the child will get as income and will help supplement their life, keep the maintenance comfort level, all that sort of thing. If you find that it's a good plan for you, we can certainly have a discussion with our office. We're more than happy to. And then what we would do, we would send you some literature, and then we would do the sample annuity quote to see where it is. Victoria, is there any other questions about Henson Trusts or Lifetime Benefits Trusts? I think one of the common ones is, I've seen it in the feed, is that we're talking about capacity of a child to do a will. That's a very common question. I know I'm going to segue, my apologies, but like I said, most common questions is, I have a disabled child, can they do a will? Well, there's a test, and we're talking about capacity to understand the extent of their property, understand that they have stuff, like they have furniture, the RDSP, a bank account, possibly a car. Do they have the capacity to understand that they have that? Do they have the capacity to understand that when they pass away, they give things away to people, like to, their Toronto Maple Leafs jersey collection to their sister, or their Blue Jays collection to their brother. Now, they understand that when they die, the people get that. Do they understand that the possible claims that relatives have on their property, like, the brother is like, well, no, actually, I want the jersey collection, and the sister's like, well, you can't have it, that sort of thing. And I think finally is that, they understand the relationships of, people, like I said, making claims on the estate, making claims that, do they understand that leaving a potential beneficiary out of their will actually leave it open to a possible challenge? Like, for example, say my brother passed away, he promised me his Calgary Flames jersey, but he leaves it to his niece instead. And would he understand that I could possibly make a claim to that? So if your child has the understanding of all of this stuff, then they could potentially make a will. And we'd be more than happy to discuss that as well. So, because like the RDSP will fall under the beneficiary's will, but if the beneficiary passes away before the parents, what will happen is that the child's estate will go, we go by succession law. And so first of all, does the child have surviving parents? Yes, the property will go to the surviving parents. No parents, any potentially siblings that they have, or children, if they have any of that. That's, that's where the table of succession will come through, that, a person who is incapable possibly cannot have a will, and therefore we would have to look at intestacy law. Let me see, I believe that's it. Is there any other questions about wills?
Oh, that's good. Now,
Okay.
that's well done. We'll carry on to the next slide.
Okay.
Okay. So this is one way to fund a trust, and that's with life insurance. If you happen to be a younger couple, presently have a modest estate, say you're a single mom, let's just say, okay? You're a 50-year-old single mom, you have a son with disability, 18. So your life expectancy is 35 more years at that age. The older you get, the longer your life expectancy actually is. But at that age, it's about 35 more years. So if you don't have much of an estate and you'd like to make sure there's something, these are just multiples of 100,000, so you could go with any number you want. But if you were to purchase a universal life policy, which is a fixed premium, certain to pay on death, and the premium was $115 a month for 100,000, that's 115,000. Sorry, I'll try 150 times 12 is 1,384. So it'd be approximately $1,400 a year. But of course, now your child is on ODSP and they're getting $896 or $1,169 a month. So if you were to purchase such a policy, it would pay $100,000 designated directly to you, the trust in your will. And if you tried to save that money, if you thought, well, I won't do that, I'm going to put the money aside. I'm going to save it. I'm going to invest it, and I'm going to pay tax on what I earn. You can see that, in simplistic numbers here, if you tried to save the premium to have 100,000, you better not die soon, because you have to do this for 72 years. So one thing that a lot of people consider to segregate their concerns about that particular child, if they have several children, and the funding of the trust for that child, they segregate this issue with life insurance, and it's a perfectly good solution. Do we have any more special questions, Victoria, about wills or disability credits or any of those things?
Yeah, so there's actually one thing that no one touched on that I think would be a good question. Teresa asked, can you have a Henson trust for a person with no disability? And I think Peter said that he would like to answer this question.
Yeah, that's a good
Sure,
thing.
yeah. Yeah, so obviously we've been talking about Henson Trust in the context of people with disabilities, but they are, the short answer is yes. Oftentimes you have family members that might not necessarily have a disability, but maybe they have trouble managing their finances or other things that might stand in the way of you wanting to give the inheritance to them directly. So the short answer is, yeah, you can have a Henson Trust for people that don't, strictly speaking, have a disability. Actually, I'll just quote from we have that Henson Trust ebook, which I highly recommend everyone check out if you haven't already. But there's basically 3 reasons that you would want a Henson Trust. One is obviously to plan for your child's care when you're no longer around. The other one, applies more to if they have a disability, is to protect their ODSP and other government benefits. But most importantly, it's to help family members manage their daily affairs, regardless of their level of disability. So the short answer, yes.
Yeah, and I'd like to chime in a little bit too. I remember one family where we did a will for the daughter, the trust for the daughter who had some disabilities. But we also did one for the brother who was a personal injury lawyer. And one hopes that he was, well compensated for his work. and he had a second wife and 5 children. So given that he'd already gone through one divorce and he had 5 kids to support and he was in a high tax bracket, what we did was we set up a trust, and it was a Henson trust. And he was the trustee of his own inheritance. And he and the 5 children were the beneficiaries. So he could draw capital, but the income that was generated on this inheritance, he attributed to the children. And they each had personal tax credits, just like everyone else, of, upwards of $13,000. They had no disabilities, none of the kids. So what happened was he was able to attribute the income to the kids and pay no tax, which is good. And we didn't push this point, but the point is that this inheritance held in this trust is again exempt from divorce. So if he were to, it's a terrible thing to misplace 2 wives, but if he was to lose another one, and if there was a claim against this inheritance, it wouldn't go anywhere. He could even file for bankruptcy, and the trust would still be protected. So it's a very powerful tool. We've got about 10 more minutes. Anybody want to make any other contributions, or shall I just
Ken,
chat a bit? Yeah, Karen, yes.
I have a Justice David that has a question, actually 2. He was hoping that you can help out on this webinar.
Sure.
I guess you prepared some Henson trusts a while ago for him. The Henson trust, is it transferred to British Columbia? And how can that be done for their family? And also wants to know, they have power of attorneys for their children, but do they need actual legal guardianship?
Well, the first question is, Henson trusts are effective in all provinces. And it doesn't matter whether the trust provision is in a will that was done in Ontario, but you die in BC, it's not material. I guess it's probably prudent to redo a will in BC, but there's no need for it. They're essentially the same in all provinces except Quebec. So, if you move to Quebec, either to it or from it, you'd probably be prudent to redo your will. But otherwise, the Henson trusts are effective in all provinces. And there's nothing special needs to be done. In fact, if someone is a trustee of a trust in a will in Ontario, but the trustee lives in BC, the only thing that changes, because of course the child, the beneficiary, could well be resident in Ontario or not, but the residence of the trust is determined for tax filing purposes by the residence of the trustee. So it's all very much translatable across Canada. And then with respect to powers of attorney and guardianship, if you can get by with guardianship, if there's no issue, if the child's competent, well, obviously they can have power of attorney. But there's lots of cases where, we believe in the least intrusive, least restrictive, most economical solutions. So if you can do a power of attorney for a child who is presumed to be competent, and if it appears that they are competent, perhaps with limitations, but if you can get the cooperation as a parent that you need with that power of attorney, like for example, to file their tax return. If you file a power of attorney signed by a child with Canada Revenue, they won't question it. And you can then proceed to file their tax returns because everybody's happy. Canada Revenue wants you to file their return, and you want to file it because every year you file it, the child gets about $900 in other benefits. So, but of course, if you have a child who's not competent, truly, and you know that when you're gone and the other child, the alternate attorney, goes to wherever the RDSP is being managed and presents the power of attorney signed by their brother, and the brother's with them, well, when you're dealing with, investors group or whatever, because that's where the RDSP is, are they going to concur, or is this going to be a problem for the other boy? So when at that awkward age, what you do is you just look at whether you want this problem to be passed on to his brother, or whether you would prefer that you seek legal guardianship now jointly for the parents and the siblings. And then when the parents are gone, the siblings continue on as the survivor guardians. It's a tactical discussion, and these things, there's costs involved, thousands of dollars. So we don't do them unnecessarily, but it's a very steady part of the practice. Is there any other questions?
Shirley had asked, I had a will set up with a Henson Trust 3 years ago. Can I change my trustees?
Absolutely. Nothing's written in stone. You just either redo the will because there's several things you want to update, or perhaps you do a codicil. And when you change executors, replacement executors or the party who was the executor, they rarely complain that they've been removed. If we were redoing a will that had bequests in it, for example, for money or items, cars, boats, cottages, this kind of thing. If we were doing a will with bequests in it where either the amount of money was being reduced, for example, or the gift was being removed, we wouldn't typically do that by way of codicil. We would do that with a new will, so that there's no evidence of just when it was reduced from 200,000 to 100,000, because it'll coincide with some family event where somebody had a fight or something. But otherwise, there are things that could be done just with the codicil, and changing executors could be one of those. Oh, we're doing well. We got about 4 minutes left by my calculation. We've got 414 people still in attendance. We had 451, so just about everybody has stayed till the end. We try not to keep people too long on these evening events. If anybody wants to sit in again tomorrow at lunch, just invite yourself again with the old invitation. And you can sit in again and ask questions again if you wish. We have, I said, 504 are already registered for tomorrow. So that's a total of about a little over 1,200 for these two events. We had 451 attend today, so we should have something like 350 or perhaps 400 take part tomorrow of the 504. And I wouldn't doubt that 504 goes up overnight. I expect that we'll do a Ask the Expert Q&A in a few weeks. You may want to take part in that. You'll get notice. And the next day or two, the recording of this and the PowerPoint will be sent out to everyone. Feel free to review them or pass them on to others. They'll be posted on the website and on the YouTube channel and so on. I think that's about it. What is it now? It's 8:13, so we're just right on time. I'd like to thank everyone in the office for taking part. We did a great job, thank you. And we'll do an even better job tomorrow. So with that, I'd like to wish everyone a good evening and a safe evening, and a time to relax and enjoy themselves later.
Have a good night.
Good night.